Okay, Robert. Well, let's go to one that I'm very familiar with. The Eric Swalwell, the man. When I did this video today, the internet is so funny because, first of all, before I published that video, my wife watched it and she said, "Oh, Dave, isn't Swalwell the guy who had the Chinese spy girlfriend?" And I was so proud for a moment because she remembered, she knew, she watches, she learned, and I forgot to mention it. And my goodness, is every other comment in that video, Viva. Swalwell's not known only for his fart and nukes. He's known for having a honeypotted relationship with Fang Fang. I think that was her name. And I'm not trying to be mean. I think that's the nickname that he had for her. A Chinese spy. But that's the backstory to this, is that Swalwell, Eric Swalwell, rep from California, sued Donald Trump, president at the time, for whatever was left, Donald Trump Jr., Giuliani, keep getting his name wrong, Mo Brooks. Mississippi rep, for damages as a result of their speeches, which incited. Make sure everyone sees this. I'm not agreeing with this. Incited the riot, the insurrection. I feel like Chris Farley in Saturday Night Live. He sued them for damages, among legal fees, and he sued them for. I guess it qualifies as a permanent injunction to issue written notice to Swalwell when they're going to hold a rally, a political rally, or an organizing event of a certain amount of people that could impede the functions of the government. This is what he was suing for. Trump, a month ago, filed a motion to dismiss on the basis of presidential immunity. Unless I'm mistaken, no judgment rendered in that. In the meantime, Mo Brooks filed a motion to dismiss on the basis. Oh, no, sorry. He filed a request that the Justice Department take up his defense under the Westfall Act, which is the Federal Torts and Claims Act that governs federal torts committed by employees, where if the tort alleged was committed in the context of his employment, the Justice Department would assume his defense. He would no longer be a defendant. It would be the Justice Department. Justice Department says no in a 30-page memorandum, basically says it was a political speech, political rally, outside of your functions as a federal employee, so we're not covering you. Defend yourself, enjoy it. This frivolous suit, as far as I'm concerned, from the get-go. The question I had when asking you this, Robert, is I was drawing it back, and I'm trying to think of other examples, recent or that people would know. When was the last prominent example where the Justice Department said, okay, we're taking up the defense of the accused, and the accused is off the hook, and we'll step in? What was the last case anyone might remember?
I mean, they almost always do that. And so there are two different sources here. He could either have the Justice Department defend him and replace him under the Westfall Act, and they replace him with the United States government. That's one option. The other option was for the House of Representatives or the Congress to assign its counsel or hire outside counsel to defend him under the same grounds. Now, my own view is I agree with the Justice Department that this does not fall under the Westfall Act. And I agree with the House, the Congress, saying it doesn't fall within his congressional duties for congressional immunity for their defense of him either. But this is completely hypocritical. So these are the same bodies. So, for example, at different levels, I dealt with the Westfall Act in detail for the Covington boys and suing Senator Warren and now Interior Secretary, then Congresswoman Deborah Haaland. During that time period, They never requested that the Trump Department of Justice formally replace them. They requested it on their own separate terms, but they did have congressional lawyers defend them. But of note, the Justice Department never said what they could have and should have said, which is, oh, this is outside the scope of employment. Here's the big problem. The Justice Department has now just said that political speeches outside of Congress are not within the scope of your duties. Well, why did the courts then say that somebody putting a tweet out about kids in some other place is within their congressional duties, including the current Biden Secretary of the Interior and Senator Elizabeth Warren? Which is it? Now, I was curious whether the press would cover this with any degree of fairness or objectivity or would mention this. And instead, what they put in there is they said the Department of Justice defending Trump on libel charges from before. And they just said because of some other libel case history. And I was like, so they won't even talk about what that other libel case history is, which is the Trump Department of Justice cited the Warren and Haaland decisions as reasons why they had to defend Trump against libel under the Westfall Act. But there's different immunity for the president than there is for members of Congress. It's supposed to be broader for the president, less for the members of Congress. So what was amazing is all the legal and political discussions celebrating this was by people who also celebrated Senator Warren not being held responsible and Congresswoman Haaland not being held responsible, now Interior Secretary Haaland, even though what they did was clearly far out more removed from their duties of Congress than what Mo Brooks did.
Well, even let's just say it's equal. Let's just say it's equal so that we avoid, partisan accusations. Haaland and Warren, did the Justice Department take up their defense, or was it dismissed against them under the Westfall Act for a different reason?
Oh, it was dismissed under the Westfall Act for the same reasons. They just used Congress's paid lawyers, as my understanding, rather than use the Justice Department's lawyers. So that was the only distinction. And the reason was in the libel defamation context, that's not a recognized tort against the United States. So it would automatically be dismissed anyway. So that was the only distinction, is this tort is different than that tort, but it's the same core thing. It's amazing for the Justice Department to now. Why didn't the Trump Justice Department say that during the Covington boys case? Shows how useless Trump's own Justice Department was. But putting that aside, the logic is identical. Because they're saying if you make a speech for political purposes outside of the halls of Congress, not within the scope of your duties for the Westfall Act. Well, that directly rebuts what happened in the Warren and Haaland cases, and in fact, in every other predecessor case. No,
but you're going to get into such a level of minutia of detail that they're going to wiggle out of their hypocrisy. They're going to say, yes, Elizabeth Warren, when she tweeted it, it was a matter of national concern, it was a matter of national concern about the wall. I mean, that's what they said. It had to do with the wall.
How is it any different? Clearly, Mo Brooks' speech was about matters of national concern. Their view is what matters is where they took my argument from Warren and Haaland, my cert petition that they chose not to get involved in, and they replicated it because now the target is a Republican they don't like. But I mean, I like the law. The law is right. The Westfall Act shouldn't apply outside the halls of Congress for a member of Congress. But the Justice Department was pretending, and a lot of legal commentators were pretending that this wasn't a complete reversal of the position the Justice Department has had for 20 years, really more than 30 years since the Westfall Act was passed. Ted Kennedy, who was initially sued, he made his statements at a political fundraiser outside of the halls of Senate. And yet the Justice Department said that was immune from speech. And it was the only difference between this case and those other cases is that these are this is a disliked Republican, and almost every other major case involved a politically protected Democrat. That's it. The Justice Department, after 30 years, has completely reversed course on what constitutes the scope of duties under the Westfall Act. And the only explanation that I can see is politics. Now, I think they're right now, and they were wrong before, but it was an extraordinary reversal. Let's see if they'll hold this up consistently. Will they do this the next time Maxine Waters is facing a libel suit? Some of these other people are facing libel. Are they going to take the same position, or will they suddenly do something different? For example, this may be a good bridge. Into the libel suit brought by from the impeachment trial, they've brought it currently just against the discovery company, DOAR, which I'm familiar with from back in the day, because that company helped facilitate that fake tweet that they used in the impeachment hearings.
Okay, hold on.
And maybe could she expand to add the congressman for statements they made outside the halls of Congress, or will the Justice Department suddenly reverse itself again on what the Westfall Act covers?
Well, that's the amazing thing is no one's going to accuse you or me of political hypocrisy or opportunism because we had been saying from the beginning what Elizabeth Warren and Deborah Haaland tweeted was not in any meaningful sense within their functions and should not be. And what Mo Brooks did follows the same logic. Let him get sued. I think the suit is frivolous. I think alleging that Mo Brooks, alleging what Mo Brooks said was inciting a riot is garbage. Alleging what Elizabeth Warren and Deborah Haaland said was defamatory, in my opinion, is respectfully true. But to say that the Department of Justice should defend either of them, I'd say no. These are things they took the risk of saying them. It wasn't part of their job. They might have been doing it to please their constituency, but it was definitely not part of their functions. And they went out on a limb, and they should have to defend themselves. Fine. But it is just an unequal balance. Like this is the arms of justice just tilting to the left into the saying Elizabeth Warren and Deborah Haaland. The suit gets dismissed for sovereign immunity because they were in their functions of employees, federal employees, but Mo Brooks has to pay his own lawyers. Now the suit continues. They don't take up his defense. He has to defend himself at his own cost and in an unfavorable jurisdiction. So they'll dismiss this on the merits, but not after a long, lengthy, costly fight. And that's the two-tiered system that politics destroys. I didn't flesh it out in this detail in my video today, but yeah, I think if Mo Brooks incited a riot, he should have to defend himself. I don't think he did, but Elizabeth Warren, these are analogous in the sense of they were both outside the scope of their employment. One gets dismissed, the other one has to go defend himself at his own cost.
Yeah, exactly. And there may be forthcoming legislative proposals from Congressman Thomas Massey and from Senate candidate J.D. Vance to make it clear that the Westfall Act doesn't apply beyond the limits of the Speech and Immunities Clause of the U.S. Constitution, which is where it was until 1989. Until 1989, you as a member of Congress could be sued for your statements that were not protected by the Speech and Immunities Clause, such as statements made outside the halls of Congress that didn't have a close nexus to activities within Congress. Your traditional scope of duties kind of analysis. It was only after 1989, when mostly Democrats were being sued, that courts and the Justice Department rushed into their defense and dramatically expanded the Westfall Act to mean something it legislatively was never intended to mean. And it's good that they're suddenly reversed, but we'll see if they'll be politically consistent about this, or if this was just, hey, two sets of rules for two different classes of people.